Is 9:30 and we are going to start the class now, and I will share my screen now. The screen which I am going to share is yes.
Good morning, sir.
Before the other, I will say good morning to everybody, and the class is in progress now. And before the other people will join, let me give the explanation regarding the what are the direct taxes, what are the taxing statutes, and generally, we'll say direct taxes, that is comes the income tax, wealth tax, gift tax. These are said to be the direct taxes. But when you come to the matter of the indirect taxes, central excise, custom duty, sales tax, service tax. But now sales tax is changed now because there is no central excise duty and some state. Now it is in its place. GST has come, so GST will be applicable now. So today class is regarding the taxing statutes. If the taxing statute should be construed, how it should be construed, that is the point. Before the people will join, let me say, wait and see that people, let me say to you, good morning. Yes, I would like to say the good morning. It is my screenshot which I made over there. And yes, the things is, yes, good morning to everybody. And today is the taxing statutes. And taxing statutes, as you know, that whatever the taxes should be levied by either the government, both the central and state governments are concerned. And but when they are making such a statute, they have to say that it should be construed very strictly. That is the point which it clearly says, and you will see one after another. And the people are joining now. And so let me say the good morning to everybody. Um, as for the statutes are income tax statutes, is a statute, and wealth tax is also a income tax, that is a tax statutes. So whatever the tax statutes should be there, generally it should be construed strictly because there should not be any loopholes in it and there should not be any ambiguity in it. That's this today class says about it. Then we'll see what is actually the strict construction. Then I will share this video screen. Then we will go to the today's class. Actually, what the today class is. Yes, we'll see the participants are joining one after another. Okay, I will say before they could join. Yes, now the time is 11:34. Yeah, let me deal it because one after another will join the strict construction of taxing statutes. So our scheme of our flow of online lecture is given below. Like first I will do the introduction, then tax system in India, taxation, the tax laws, then I go to the principle of strict construction, then come to the point of strict construction, and with the taxing statutes we have the different subheadings like the charging section is there, and clear intents to impose or increase the tax, and prospective operations, meaning in common parlance, machinery provisions, no presumption as to tax is concerned, and fiscal statutes to be read as a whole. No spirit of law would be followed, only the letter of law would be followed in generally, and a substance of matter is concerned, and how it could be construed. Then the last, the exemption clause, that is the strict construction. Then we'll come to the conclusion how these, what are the things we should have to keep in mind when you are construing or interpreting the tax statutes. Then we'll see the participants. Yes, participants one after another joining, and yeah. So let me continue my class regarding taxing statutes are concerned. Yes. So in the introductory part, let me say, in regard to tax legislation, and especially Income Tax Act come first in particular, of course other tax laws also there. The language imposing the tax must receive a strict construction. Either in the Income Tax Act or any other act which is related to the tax as concern, it should be strictly construed. In a taxing act, one has to look at what is clearly said. There is no room for any indentment. There is no equity about a tax, and there is no presumption as to tax, and nothing is to be read in, nothing is to be implied. One can only look fairly at the language used in the statute. Statutes imposing taxes or monetary burdens are to strictly construe. The logic behind this principle is that imposition of taxes is also a kind of imposition of penalty, which can only be imposed if the language of the statute unequivocally says so. Any kind of indentment or presumption as to tax does not exist. Tax and fee. In case of fee, there is a specific service rendered to the fee payer. There is a quid pro quo. Whereas for the taxpayer, no direct services are rendered, but the services assume the form of public expenditure rendered to the public at large. So let we see how the tax system in India. The tax system in India reflected the characteristic of a traditional agricultural economy, and revenues of the central government were dominated by custom duties as a domestic requirement for manufacture of goods were dominated with the custom duties, and the domestic requirement for manufactured goods were met mostly from the imports, chiefly from the Britain and other Commonwealth countries, or any other country also where we are making imports. When the import duties were levied in almost all items of import, whereas major items subject to the export duties were mainly the jute and tea, or of course, the India is now exporting the many other goods also. So when we are exporting, there is the exporting duty also put it over there when they are exporting to the world market. Various customs and tariff enactments were passed from time to time. So these are the tax systems in general in India. Then we'll come specifically what is taxation. The Article 265 of the Indian Constitution, that is the Constitution of India, mandates no tax shall be levied or collected except by the authority of law. It provides that not only levy but also the collection of tax must be under the authority of some law or same law. Here, what I want to say is, whenever you want to collect the tax, yes, there should be some law should be there, and that is clearly said in the Constitution. Then, what are the tax laws? Let me throw light on the tax laws. Tax laws are highly complex, complicated, and beyond understanding of taxpayer. The word and expressions used are not simple. Many sections contain subsections, clauses, subclauses. Many deeming provisions have been inserted, and meaning of an expression is extended by way of explanation and is curtailed by the way of proviso. Sometimes more than one proviso and explanations meaning differently. So that was the tax laws of India, how they are made, in what structure. Now we'll concentrate on the principle of strict constructions are concerned. How the tax statutes are strictly construed. The manner in which the Income Tax Act has been drafted leaves a great scope for the litigation. Not only income tax, in any other tax laws are concerned, generally no statute will be free from some loopholes. There are some or any other form of loopholes will be there. For this purpose, principles of interpretation has to be applied. So when there is an ambiguity and when there is no clear intention of the parliamentarian would be known, at that instant judiciary come into the picture and interpret the statute. These principles themselves are not infallible and would depend on the facts of each case. The two well settled principle of interpretation as applicable in taxing statutes. So there are two main principles will be followed in the taxing statutes are concerned. That is number one, there is no equity in law, and the principle of strict or literal construction applies in interpreting tax statutes. Hence, on the plain language of the statute will be taken into consideration. If the SSC is entitled to two benefits, I repeat, if any SSC is entitled to two benefits and he has to be granted both these benefits. That is the rule 1 says. And I'm come to the rule 2. If there are two reasonable interpretations of taxing statutes, I repeat, if there are two reasonable interpretations of taxing statutes, the one that favors the SSC has to be accepted. So a lenient approach is given over there. This is generally the principle is concerned. And when you go further, the exceptional clause, the Supreme Court has given the judgment, and we will go through in this class. Now, if any ambiguity comes in the exceptional classes, then it should be in favor of the SSC was there earlier, but the Supreme Court overruled it now. If any ambiguity in the exceptional class is concerned, the favor should be given to the state. Of course, we'll read with the case laws also when we go further. A statute is an edict of the legislature, and the conventional way of interpreting or construing a statute is to seek the intention of its maker. So, it is the structure of the legislature that the statute is, which is made, but you have to see what is the intention of it is making such a structure in the form of a statute. A statute is to be construed according to the intent of them that make it, and the duty of the judicature is to act upon the true intention of the legislature. If a statutory provisions is open to more than one interpretation, the court has to choose that interpretation which represents the true intention of the legislature, which is also referred to as the legal meaning of the statutory provision. So let me go further. The intention of the legislature assimilates in two aspects. Now we will see how the intention of the legislature will be taken shape. That is, they say the two aspects. Number one, in one aspect, it carries the concept of meaning. That is, what the words mean. That is one concept. The second one is, in other aspect, it conveys the concept of purposes and object, or the reason and spirit pervading through the statute. It is second aspect says not only on the words, the spirit of the words, the circumstance of the words, and the object of such words, and the reason for that words, and that would be considered over there. That is the second aspect of the intention of the legislature. But generally, we will see only the first aspect of it mostly in the taxing statutes. And now come to the strict construction is concerned. In interpreting the taxing statutes, the court must interpret the statute as it stands, and in the case of doubt, the court must lean towards the taxpayer. So a leniency will be given for the SSC that the taxpayer when such a let me see if any other participants here. No one is waiting over there. So here it clearly says the leniency should be given to the taxpayer whenever such two interpretations comes. The words of fiscal statutes neither are to be neither elaborated nor restricted. So here fiscal statutes is nothing but the tax statutes, and it should be neither to be elaborated nor restricted, but as it is, the word which says that the exact meaning should be taken, should be interpreted in the taxing statutes. The basic rule with regard to the construction of taxing statute is that they should be strictly construed. Yes, we are saying every time. The well-established rule in the familiar words of Lord Simons and reaffirmed by the Lord Hawkesbury. These are all the two lords like Lord Sutkin, Lord Chester, Lord Blackburn, Lord Denning. So they are Simon and Hawkesbury. They means what the how the taxing statute construed. This is the subject is not to be taxed without a clear words for that purpose. I repeat, the subject is not to be taxed without a clear words for that purpose, and also that every act of parliament must be read according to the natural construction of the words. In a taxing act, one has to look merely at what is clearly said. There is no room for any indictment or presumption or some other explanation or presumption, as I just now say, as to tax is concerned. So clearly it says there is no indentment, there is no replacement, there is no substitution, there is no presumption, there is no equity in tax statutes. Nothing is to be read in, nothing is to be implied. I repeat, nothing is to be read in, nothing is to be implied, and one can only look fairly at the language used in the statute. The rationale for the strict construction of taxing statutes lies in the fact that they impose pecuniary burden. Yes, tax will be the pecuniary burden, and hence, therefore, in some sense, they operate as a penalties, and it is on the basis of that the clear and unambiguous language is required in order to make out a charge of tax. Yes, because we will see the subheadings like the charge of tax and spirit of the law, as we said earlier. So now we'll go further. Before going further, let me see if any other participant is waiting in the lobby for my admit. Participants, yes, the people are there too. So I would like to say admit them. So I admitted them now. So now coming back to my resume back on my lecture. A tax is imposed for a public purpose for raising the general revenue of the state, and a taxing statute is to be strictly construed. Lord Hasbury Simon has already mentioned, and they clearly said in this way also the subject is not to be taxed without a clear words for the purpose, and also that every act of parliament must be read according to the natural construction of its words. So exactly what the word state in the statute will be interpreted, and again the Hasbury and Simon says in their decisions, that is the English laws there. It is settled law that the taxation status in particular has to be strictly construed, and there is no equity in taxing provisions was observed in the case of H.H. Lakshmi by versus Commission of Income Tax, which clearly says there should not be any equity in taxing statute. What is said, that should be implemented as it is without any deviation. That is mentioned in the case law. Then that the same thing is mentioned. The subject is not to be taxed without clear words for that purpose. So the clear word should be there for the subject. So that is they say the subject is not to be taxed without clear words for that purpose. That is seen in the CIT. That is the Commission of Income Tax versus Prudent Investment Company Limited. In that case now. In the case of A.V. Fernandez versus State of Kerala, that is AR 1957, the lordship, that is his lordship, we can say in other words, his justice or his lordship, Bhagwati, has stated the principle of taxing laws as follows. So like we mentioned Simon and Hawkesbury, so here the Justice Bhagwati, his lordship has stated the principle of taxing law as follows. In construing fiscal statute, here fiscal statutes means those who are related to the money or tax. In construing the fiscal statutes, And in determining the liability of a subject to tax, one must have regard to the strict letter of law. So he said, strict letter of law should be followed. That means the spirit of law will not be taken place over there. If the revenue satisfies the court that the case falls strictly within the provisions of the law, the subject can be taxed. If, on the other hand, the case is not covered within the four corners of the provisions of the taxing statute, no tax can be imposed by inference, by analogy, by trying to probe into the intention of the legislature, and by considering what was the substance of the matter. So that is the way Justice Bhagavati has stated in the A.V. Fernandez case law. When we are construing the taxing statute, and what should be kept in the mind, and it is clearly says that strictly concentrate what the act says, confined to the act wordings, and there should not be any other provisions should be included over that, like imposing inferences or analogy or a spirit or a deduction, trying to prove or any presumption. These are all not should be included over there. That is, they say, what is the intention of the legislature by considering what was the substance of the matter which is given in the statute should be considered. So, in any another case law, that is in Associate Cement Company Limited versus Commercial Tax Officer, I repeat, in Associated Cement Company Limited versus Commercial Tax Officer, where Venkatramaya, Honorable Judge, said, the Supreme Court judge, speaking for the majority, he said, tax, interest, and penalty are three different concepts. Tax, interest, and penalties are three different concepts. Tax becomes payable by an assessee by virtue of the charging provisions in the taxing statute. Penalty ordinarily becomes payable when it is found that an assessee has willfully violated any of the provisions of the taxing statutes, then only penalty will be imposed. And interest is ordinarily claimed by an assessee who has withheld payment of any tax payable by him, and it is always calculated at the prescribed rate on the basis of the actual amount of tax withheld and the extent of the delay in paying it. So these are the three aspects clearly mentioned. They said, what is number one? He said tax becomes payable by an assessee, what is tax, and penalty, how it can be imposed. And the last one is if he willfully withheld to pay, that is in regarding the interest is concerned. So tax, penalty, and interest, how it will be there, it is clearly mentioned in this case law by the Justice Venkatramaya. So he says it may not be wrong to say that such interest is compensatory in character and not penal. So those are the three terms based on that we have to strictly construed. It is said in that case law. So now we will see how the remedial statutes are there. So remedial statutes are known as a welfare, beneficial, or social justice oriented legislations. But penal statutes, on the other hand, are those which are provide for the penalties for contravention of law and are directed against the offender in relation to the state by making him liable to imprisonment, fine, forfeiture, or other penalty. So generally remedial statutes are liberal in nature. It is a welfare legislation and there is social justice should be given and it will be liberally construed. But whereas the penal statutes are concerned, you should be construed very strictly. No deviation. So again we will come to the remedial statute receive a liberal constructions, whereas penal statute is strictly construed. I repeat, a remedial statute receives a liberal construction, whereas a penal statute is strictly construed. So, in case of remedial statutes, the doubt is resolved in favor of the class of persons for whose benefit the state statute is enacted. Whereas in the case of penal statutes, the doubt is resolved in favor of the alleged offender. So, that was the difference between the remedial statute and the penal statute. Then we go further Let me see if any other person is waiting for the, yeah, no person is waiting over there. So let me resume it. The principle applied in constructing a penal act or a penal statute is that if construing the relevant provision, there appears like penal act, like in the same manner, the taxing statutes also be made, because imposing the tax or collecting the tax is a form in another form, is an activity like a penal. So because if they violate it, they will be penalized. Yeah. Let me resume. The principle applied in the constructing the penal act is concerned or tax act is concerned and construing the relevant provision, there appears any reasonable doubt or ambiguity is there. It will result in the favor of the person who would be liable to the penalty. Generally, lenience will be given to the SSC here. That is the taxpayer. If there are two reasonable construction at the time, we must give the more lenient one. That benefit should be given to the SSC here. Yeah, the tax actually SSC or a taxpayer. The court must always see that the person to be penalized comes fairly and squarely within the plain words of the enactment. I repeat, the court must always see that the person to be penalized comes fairly and squarely within the plain words of the enactment. So it is not enough that what he has done comes substantially within the mischief aimed by the statute. So that was the how the penal taxing statute should be construed. So let me go further. A penal provision has to be construed strictly, naturally. In the same way, the taxing statutes like a penal, they should be construed very much strictly. So let us throw a light on these side headings, like I told you, prospective operations and meaning in the common parlance. What are the machinery provisions? Whether to impose no presumption as to tax is concerned, and a fiscal statutes to be read as a whole. No spirit of law would be followed, and substance of matter, and the lastly exemption clause, that is in strict construction is concerned. Let us see the impact of the strict construction of statutes in the following uh, subheadings. Let me see if any other person is a participant. Yes, he is waiting. That is Nageshwar Rao. MNR is waiting. I admitted him. Nageshwar Rao. Yes. Now he can hear my class and he can resume. So subheadings are regarding I have given at least 7 to 8. So the subheading in the first one is charging section. So that is charging section would be there in the tax. In any the taxes are there. How the charging section should be levied or should be constructed. It is given in this subheading charging section. So, foundational principle for the charge under the tax statute: no tax can be imposed on the subject without words in the act, clearly showing an intention to lay a burden upon them. So, the statute clearly shows what is the charging section, and the charging section should have very clearly written that with the words of whom should be charged and what respect and how much the levy. The section that charges the tax must be have clear words. Before taxing any individual, it must be clearly established that the person to be taxed falls within the purview of the charging section by clear words. I repeat, the section that charges the tax must have clear words before any person will be taxed. So before taxing any individual, it must be clearly established that the person to be taxed falls within the purview of the charging section by clear words. There is no implication of the law, and there is no presumption, there is no equity, and there is no indentment. So, if a person cannot be brought within the four corners of the law, that is, I repeat, if a person cannot be brought within the four corners of the law, that's what the statute says. He is free from tax liability. So that we already seen in the A.V. Fernandez case law, where Honorable Justice Bhagavati made such a statement how the um, taxing statute should be construed. See, we'll see that in the Calcutta, in the case of Calcutta Jute Manufacturing Company versus Commercial Tax Officer, the Supreme Court held that in case of interpreting a taxing statute, one has to look into what is clearly stated. I repeat, the Supreme Court held that in case of interpreting a taxing statute, one has to look into what is clearly stated in the statute. There is no room for searching the intention, presumption, or equity, or indentment, or any other deviations that is clearly mentioned. And let me go through the another case law that is the in Mathuram Agrawal versus State of Madhya Pradesh. What it says, the Supreme Court held that words cannot be added or substituted to find a meaning in a statute so as to serve the intention of the legislature. Every taxing statute must contain three aspects. I repeat, every taxing statute must contain three aspects. Number one, subject of tax. Number two, person to be taxed. Number three, and the rate of tax. So these things are very important. One is subject of tax. Two, person to be taxed. Three, the rate of tax. It should be very much clearly mentioned in the statute. And there is no question of substitution, addition, and insertion in the taxing statutes. So the clear intention to impose or increase the tax. Yeah, the intention to impose or increase the tax duty must be clear and in ambiguous language. So that is very much clear. Let me say if any other participants, yeah, no other participants waiting on the lobby. So now I can proceed at least for 3 minutes, then I will stop it, then I will give the chance for the our students to ask their doubts. Yeah. So the intention to impose or increase the tax or duty must be clear and unambiguous in the language it should be stated in the tax laws. Of course, sometimes tax will be increased, tax will be decreased, and some more taxes will be imposed. But when such a insertion will be there, we already seen that it is made with the amendment to the particular act. The amendment will come later on. Then only the amendment provisions will be incorporated in the main act. So, Amendment Act that also to be notified in the official gazette that we discussed in earlier classes when we are dealing the TGCA, that is the General Clause Act, the yeah, of 1897. In case of Steel Authority of India Limited versus Commission of Central Excise, the question was whether the raw naphtha here since number gold enter kada. So I think that is the raw naphthalene balls will say. The question was whether the raw naphtha intended for use in the manufacture of the fertilizers was exempted although it was not actually used. So now we will see how the case decides. It was held that the exemption notification only required proof that the raw naphtha was intended for use in the manufacture of fertilizers and there was no further requirement that it was actually so used. Hence, if it was purchased with the intention to be used for the manufacture of fertilizers, it was exempt, even though it could not be used for some reason subsequently. So, suppose the raw naphtha is used over there for manufacturing the fertilizers, and for that purpose it is purchased. So, the tax law says clearly it will be exempted. Raw naphtha would be exempted. Either it is used or may not be used in manufacturing the fertilizers, but it will come under the exemption clause because that's strictly followed. So now the time is 12:05. That is still 10 minutes will be in our hand, and then I will go to this case law. Then I will stop it at the prospective operation is concerned. The process of construction combines both the literal and functional approaches. I repeat, the process of construction of the taxing statutes combines both the literal and functional approaches. In the case of GM Granite versus Commissioner of Income Tax, Honorable Supreme Court observed that what one may believe or think to be the intention of the Parliament cannot prevail if the language of the statute does not support that view. Thus, object of the statute has to be gathered from the language and not on what one believes or thinks. So one believes, one thinks would not be taken into consideration, but what actually the statute says that would be construed as it is. That is given in the GM Granite versus Commissioner of Income Tax. I repeat, Honorable Supreme Court observed that what one may believe or think to be the intention of the Parliament cannot prevail if the language of the statute does not support that view. Thus, object of the statute has to be gathered from language and not on what one believes or thinks. So that is the point which is made over there. So what would be the parliamentary thinking? What would be the parliamentary, or how the court will think, or how the court will make a different? We should not go in that lines. Even if the advocate also make the court to give the interpretation like substitution, insertion, but it will not be considered over there because it's a taxing statute. So we should stick to the language and not on what one believes or thinks. So with this, I will stop my today lecture. And now the time is 12:07. I will give the chance for the students to clear their doubts. Then the perspective of operation from there subheading, I will deal it in the most probably tomorrow class. That is the next class. Then I will come to the participants to ask any doubts regarding today lecture is concerned. Yes, now I am dragging it to show it to the participants. If they have any doubts, you can ask me. So, of today class, I would like to say thank you by with this clip. So thank you very much to hear the today's class. Then we will see it. What the intention of the Yes, now I will want to hear from the students.
Hello.
How you thought of today's class and how you presumed it. The language of the taxing statutes are concerned. So any person can speak and ask their doubts. Please continue it.
Hello, sir. Seshavaram, sir. Hello.
Yes. I will ask Pagadala, Bhulakshmi Devi Pagadala. What would be your doubt regarding today class is concerned? Because we discussed the taxing statutes. There we mentioned there is no whims and fancies, presumptions, and substitutions would be not be to be made. Then what the actually the statute clearly says, and that wording should be implemented. That we discussed with the cases. So now you tell me that is there any clarification you need? Bhulakshmi Devi Pagadala is online, so I opened her and then she can speak. If not, I will give the chance to other participants who actually kept it open both the video and audio, and they can ask also question. Yes, I am hearing you. I could hear you. Please, you may ask the question. Yes, I could hear you because my speaker is working well. Because I got the sound of the disturbance there with in my earphone. That's why I said. Nageshwar Rao, who joined later,
Yes.
you want to ask any
No,
clarification,
no,
any
no, sir.
doubt, or you
No,
need
no,
some
no, sir. Suddenly
interpretation
my
of these
suddenly
taxing
my phone
statutes is concerned?
sir,
Mm,
suddenly my phone was
are you
shut
doing
down,
with
sir.
a taxing statute, taxation? Whatever will be imposed in the form of a tax by the state government or central government, doesn't matter. it should be construed in a strict words. No loose words should be imposed over there. Either the tax is concerned, or the levy is concerned, or the interest is concerned, or the penalty is concerned.
Sir, suddenly my phone was shut down, sir. That's why I am in.
Manga, you can also participate
Hello?
in my discussion and ask your doubts. Srikanth,
Good afternoon, sir.
Shakanda also present over there. I will happy that people are promptly listening. But even though one student also there, it doesn't matter to me. At least if one could also be benefited by a lecture, I feel more happy. So that's why I at least bother regarding the figure is concerned. But the figure, if we increasingly we know, there is a little bit motivation would be there for any lecture. But
Hello,
lecture
sir.
will be continued as usual. So any other question?
Hello,
Srikanth
sir.
D, you can ask me if you have any other doubt.
Hello, Seshwataram, sir.
Yes, sir, please speak. I am hearing.
Sir, this taxation department, like central excise or income tax, etc.,
Sir,
they got their own judiciary measures for interpretation, no, sir.
that rules, they have procedures. The rules are only procedures. See,
No, there's some judicial measure, it seems, no? Because the Commissioner of Income Tax has got some judicial powers also, it seems.
yeah, because any tax when you want to impose, okay, you can follow the rules. Because the Income Tax Act 1961 is having the rules. Yes, one should have to follow the rules. But the tax itself, yeah, if the tax itself there is some interpretation should be needed, and that will be resolved by the courts.
Because they themselves can impose penalty, it seems, sir.
Yeah, that rules are there, no doubt. The rules are they should follow rules, because tax law is a substantial law, and the rules are like procedures. So they follow the procedure. But as far the substantial law is concerned, if they need interpretation, then court will interfere.
So again, if the customer is not satisfied, again he will go to higher courts, it seems.
Yes, definitely. See, generally, when you are not satisfied in the district court, then naturally we will go to the high court. Yeah, from the high court, we will go to again the Supreme Court. Suppose if the decision is given the district court, and we can go for the review in the high court, or we can go for the appeal also to the high court. Yes, one can ask the question.
So the final interpretation will be from Supreme Court only.
Definitely. And moreover, see, Supreme Court, once they have given the decision in the 1971 in one of the case law, that whenever the exception clause in the income tax, where there is a ambiguity, that favor should be given to the SSC. But later on, in the latest judgment, the Supreme Court is overruled its own decision in one of the case. I will take in that next class. It says whenever the ambiguity will be there in the exceptional class of tax laws, then favor should be given to the state, not to the SSC.
Sir, these departments will never give any chance to SSCs, first of all.
No. See, naturally, if your department harass you, then we need not to keep quiet. You will approach the court regarding harassment is concerned, because no one is above the law.
पहले पैसे बनाओ, बाद में देखेंगे बस.
No. See, TDS. You know TDS, it will be deducted first, and you will remit it. Suppose if you feel that you will get, I am paying the amount of the house rent, my student fees is there, tuition fees is there, and traveling expenses is there, medical expenses are there, life insurance is there, and insurance policy is there. You can show that all the other things. Then you can the reimbursement will come to you, and directly it will come into your bank account.
Deduction at source.
Yeah. See, the deduction first, because deduction is must. Like, first deduction is there.
मैं वही बोल रहा हूँ साहब, पहले पैसे बना, बाद में देखेंगे.
Yes, पहले पैसे बनना ना, फिर बने बाद में you can ask for the remedy.
But we will go as per our rules. That's all. No, the interpretation will be from their side only.
But sometimes it may happen. Suppose if you want to get the exemption, you can for the exemption you can appeal for the court. Go to the court. So this is like in the example I have given, raw naphtha is exempted when they are preparing the fertilizers. Either he
Yes.
is using the raw naphtha, may not be using the naphtha, he will be exempted at all. But the court will not say, or the department will not say, see, you are not using the raw naphtha, so you will not be exempted. No, I may use it, I may not use it. Whether it comes under the exemption clause of the tax act or not, yes, it comes under the exemption clause. Then it's enough. It will come under the exemption.
That's all.
Yeah. Any other person?
So agreement will go to court.
Yes, please ask the question so that I feel more happy. Otherwise,
Sorry, sir, this is third unit only, na sir? We are in third unit only, na?
yeah. Because exactly, if you see it, yeah, it is comes under third unit. When you see the syllabus, see the syllabus. See, if I could jump also, but I will revert back to see to deliver it. Because after this, we will come across harmonious construction. Later on, will come that is a liberal construction or beneficial construction. This is also a primary rule only. When liberal construction, racial construction, and broad construction, and harmonious construction, strict construction, they're all the primary rules only. But only except we made four only, I dealt it first. But later on, they have given it, so I'm dealing one after another these rules in a separate way.
Sir, when income tax was enacted in India, sir, when it was started, sir, that statute.
Income tax, you want to say Income Tax Act of 1961, it is incorporated first. Then there are many amendments
Yes,
have
sir.
come.
Okay, sir. Thank
For
you.
every act, it was there. Do you think that Income Tax Act 1961, before there is no tax?
Okay.
No, there are acts are there. From the beginning, acts are there. See, if it is India is not made the act, even the British Act would be applicable as it is.
Okay, sir.
Till if it is not suits, or if there is any gap is there, loophole is there, that will be rectified by the Amendment Act. So that Amendment Act or Act repeals the old Act. So we have seen the repealing section 6, section 6A, and there TGCA clearly says a repeal act would come over there. But the repeal act come into the picture, and if the repealed act again say repealing act doesn't have any contradiction the repealed act, then it will be continued as it is. We discussed in the earlier classes. Yes, now the time is 12:18, so I encroached 3 minutes more. So let me say thank you once again, and have a good day. Goodbye, and we will
Thank you, sir.
resume our class tomorrow at 11:30. So I will close down my stop sharing.
Thank you.
Then
Thank you very much,
I
sir.
also close down end meeting. So